Hi, this is Tom Sedlak, General Manager at 33rd Company Property Management. Thanks so much for taking time out of your busy day to watch our podcast. Today's topic is how to evict a tenant in Minnesota, specifically in the Minneapolis, St. Paul, Twin Cities metropolitan area. When it comes to bad tenancy, there's one slogan that we use over and over again, and that's that bad tenants are not like fine wine. They don't get better with age. When you have a bad tenant in your property, in general, the best thing to do is to evict the tenant, is to basically pull the Band-Aid off immediately and move on. Just rip it off and go forward, because typically a bad tenant isn't going to get better. And enabling a bad tenant is actually probably one of the worst things that you can do. And of course, Minnesota Nice always seems to push the enabling button, but you don't want to do that. When you have someone that's not complying with the fundamental rules of a lease, or they're not paying, obviously, or they're doing actual damage to the property or using it in an illegal way, you really do need to take steps, and take steps immediately to reconcile that situation. Many homes are located in neighborhoods. They're located in crowded residential areas, and having a bad tenant that is non-compliant is going to cause a lot more problems than simple structural damage. It is going to rip the fabric of a neighborhood, especially with violations that are apparent from the exterior of the building. So at any rate, when you evict a tenant, there are a number of things that you have to do. The first of which that we would suggest is, if you're an independent landlord, is call an attorney that is experienced in the eviction process, and there's certainly no shortage of attorneys in the Twin Cities area that can help you. The key is to find one that has the experience and also can support that eviction in the county where that property resides. Typically, when you do an eviction, you send out a notice to terminate, to vacate, and you can follow that up with a filing from the court. The court basically will have you fill out a form, and it's called an unlawful detainer. And the reason they call it an unlawful detainer is because you've effectively notified the tenant of the violation. You've asked them to leave or vacate by a stipulated date, and now they're remaining beyond that date unlawfully. Okay, you've told them that they've in violation, you've told them that they need to leave, and now they've retained unlawfully. So it's called an unlawful detainer of real property. Once you've filed that unlawful detainer with the court, then you have to do process service. It can be done by a third party, or you can go down to the sheriff's office, and the sheriff will deliver that process service. That can take sometimes an extra week or so to have the sheriff do it. They'll send it out on their routine schedule. You can typically do private process service sometimes the same day that you filed with the court. The important thing is to get it filed as soon as possible. Court dates typically factor in the minimum notification, which is 7 days in Minnesota for process service. Has to be 7 days in advance of the hearing, and there has to be proof of service. Sometimes the court administrators will add another week or two because they know that the sheriff's schedules can be backlogged. And so you might have 21 days when in effect you could get a 7-day process if you do private service and then serve it that same day. The key, though, is making sure that you actually serve it that day, because if you're deficient in your service, then your case will be thrown out. Once the notice has been provided to the tenant, and there is a process service certification form that's filled out and given back to the court, then you just simply wait for your court date. Certainly it would be prudent as a landlord, if there are damages, to go in and contain those damages, or make sure that they're not getting out of hand. If there's a water leak or something like that, you have an absolute right to get into your property on an emergency service and fix that. If you get to your court date and the tenant is still remaining in the property, then you have to go in and tell the judge what's going on. In many cases, you have to produce a copy of the lease, you have to produce a bounced check, or any other documentation for damage or whatnot that proves that the tenant is in violation of the lease. For evictions, a material violation of the lease is typically required in order to evict. And everyone always asks, what's a material violation of the lease? A material violation would be a non-payment, or anything that is of such significance that the judge would order an eviction of the tenant for non-compliance. So if the tenant is using drugs in the property, that's an obvious non-compliance, and that would be a significant issue that would be considered material. If the tenant simply is not mowing their lawn on a regular basis and it gets to be 6 or 7 inches before they mow it the next time, that may not be found as a material violation of the lease. And so you have to be careful what you're evicting for. Make sure that you have an appropriate cause for eviction so that you can move forward and make sure that the court is going to see it the same way you are. It's also a good idea to put multiple complaints on the same eviction. So if there's a non-payment in conjunction with damage being done at the property, put all of those items onto the eviction complaint so that you have the best opportunity to paint the clearest picture to the judge and have that tenant evicted. Okay, what are some of the reasons that people evict? Well, we just mentioned a few of them. Some of them can be pretty interesting. We had one property that we had a handyman out working and on the outside of the property, and he noticed a lot of cackling birds. And he looked around and there weren't any outside. Well, apparently they were all inside, and in fact there were about 37 parrots that were inside the property, and the tenant was running a unlicensed bird shelter program for wayward parents, because everyone knows that parrots outlive their owners, and sometimes they get abandoned as the owner passes on. Nonetheless, that was a complete violation of the lease. More so than that, it actually violated local ordinance because they had more pets than the local city ordinance would allow. So, of course, both of those complaints, the lease violation and the city ordinance violation, were both put on the eviction complaint. And that's important to know because if the judge found that a simple violation of the lease was not material, they may not have evicted. Obviously, in this case, with 37 birds, that probably would have been material, but nonetheless, the ordinance violation was material. They were violating the law, and they didn't register those excess pets. And so that's why it's important to put multiple complaints all on the same unlawful detainer complaint form, so that, again, you have the maximum ability to paint the broadest picture to the court to award a judgment for possession of the property. Once you're in court, there's really only two things that are going to happen. You're either going to get possession back or you're not. Housing court and evictions is all about possession. It's not about claiming damages or judgments. You might get a judgment for maybe lost rent. If they miss the rent, you might get awarded 1 month's rent, but they're not going to award damages or anything else typically in housing court. You have to go to conciliation court for that. So don't expect to provide the judge a litany of costs and a list of expenses that you want reimbursement for. Housing court is for possession, and that's what you're going for, is to get the possession back. And once you have possession, then you aggregate those damages, you release the property, you aggregate the lost rents, the utilities, the damage to the property, the turnaround costs, releasing fees, all of those costs, you pull them all together, you drop them into a general complaint for conciliation court, and then you file, and of course you have to do a skip trace with your collection company to find out where the person is now living. So all difficult things on the collection side. When you do get a judgment, it will be entered into the court record, and the only way that can come off the individual's record is what's called an expungement. And sometimes in negotiating tenants, landlords will negotiate with the tenant. If they pay the damages, they will not oppose an expungement request or an expungement effort done by the tenant to get that eviction off their record. Sometimes it's a little bit of a negotiation, but that is something that typically experienced landlords can do, is to say, hey, if you pay me everything you're due, all the damages and everything for this entire debacle, I won't oppose an expungement effort that you do. In other words, if you go to the court and appeal the eviction being on your record, the court will remove it as long as the request is not opposed by the landlord. So there are some little things you can use to negotiate to help incentivize getting payment. I hope that's helpful. Again, like I said at the beginning, bad tenancy is not like fine wine. It's not something that is going to get better with age, and you need to take care of it right away and get your investment property back online and get that cash flow running properly again. Hope this has been helpful. If you have any questions, or if you'd like to inquire about the property management services that we offer at 33rd Company in the Minneapolis, Twin Cities, and St. Paul area, please feel free to give us a call. Thanks so much.